All right, good morning, everyone. I'm looking at everyone's faces online and making sure you're all looking as if you can comprehend me and therefore our sound is working. I know all of you here in the room, you can all hear me, I'm sure. Great, it's with great pleasure I can welcome you all to our latest UCL Public Law Group public seminar. We've had lots of interest in today's topic and in today's guest speaker. I'm going to introduce him briefly, and then I'm going to explain how our format will work, and then I'm going to get proceedings underway. First of all, I should introduce myself. I'm Professor Colm O'Caneva. I'm Professor of Constitutional Human Rights Law here at UCL. Our speaker today is Dr. Robert Craig from the University of Bristol, formerly of the LSE and Durham. Robert will be well known to many of you from his articles in the Modern Law Review and other publications, and he's writing this very exciting book on the prerogative, which is causing rows and disagreement the length of the UK, which is exactly what we want to hear. And it's with great pleasure we're welcoming him today to talk to you about the prerogative and to give you a taste of his forthcoming book and the key arguments in his book. Robert is going to, in particular, speak to two specific parts of his book: the introduction, give you an overall sense of the project, and chapter 7 of his book, which pulls together many of the key conclusions as to the origin and scope and extent of the prerogative. It's fair to say he radically reimagines the prerogative and the scope of the prerogative, or as he would see it, perhaps, actually uncovers, if you want, the real truth of the scope of the prerogative and its historical and contemporary extent, and argues for a sort of quite, well, I'm not sure you'd accept the term radical, but I'll use it, a sort of radical reconfiguration of conventional understanding of the scope and nature of prerogative powers in the UK. So it's a very, very exciting project. How we're going to deal with the format is that Robert's going to speak for around 20 to 25 minutes. And then we're going to have respondents from Daniella Locke in Oxford, Ewan Smith, who will be joining us from Los Angeles. They'll respond very briefly, and then we're going to open up the conversation more generally to people in the room and people online. So if you have questions that occur to you, put it in the chat, and I'll pick them out and ask you to present your questions orally. Great. Okay. I should also say the meeting's been recorded. Yeah. Yeah. Do I need to pick it on? Do I need to start it? I think you started. Oh, great. We're right. The meeting has been recorded, and obviously you're all, as usual, consenting to being included in the recording if you're speaking. Great. So without further ado, I'm going to hand over to Robert to present his research on the prerogative. And I'm going to share screen and pull up his presentation. Okay.
So try to get across a bit. And then
sorry, just adjusting the usual slideshow.
There's the one you want. Excellent.
There we go. Great.
Brilliant. That's great. Can I start by thanking Colm O'Caneva for hosting me today? In my opinion, Colm represents the acme of genuine academic open-mindedness. We disagree on basically everything, but our discussions are always totally respectful, and he has repeatedly encouraged me, as a very junior academic, to publish so that my viewpoint is out there for discussion. For me, he epitomizes the professionalism and maturity that is sometimes lacking in public discourse. Can I also thank Daniella and Ewan for taking the time to read the draft chapters and acting as discussants. It's very much appreciated. These two chapters are the introduction and the final substantive chapter, not the actual conclusion, of a forthcoming monograph, which started life as my PhD some years ago. This seminar at UCL is the last in a series of seminars around the country where I have sought to get feedback on the different draft chapters. The credit for doing this before publication of the book goes to Gavin Phillipson, who pointed out that processing the feedback would be a bit late after publication. So I hope to submit the manuscript sometime later this year, during my study leave, which starts basically now. And ideally the book should be out next year. So that's the plan. So doing a pre-publication book tour is by far the best decision I've made in my short academic career so far, and I thoroughly recommend the idea. My publisher said, I wish all my authors did this. So I pass on that little snippet of publisher wisdom as well. Finally, in these initial remarks, I should mention that the seminar is the closest to a more general review of the monograph as a whole that I've done, which is fitting because it's the last one, which is why we circulated the introduction and the last substantive chapter. And like the previous seminars and individual chapters, I therefore welcome questions on any aspect of the project and will try to cover as much ground as I can in my allotted time. But first, some excitement. Book covers. Oh, this has been hilarious in all the seminars I've done. So you've got a choice. I don't know, we have a voting mechanism. Oh, it's too complicated. In the chat, then, do you think that which of these book covers do you prefer? That's we've got some live ones as well. Got some people in the room. Bit of interactive audience participation. Let's have a hands up. Who thinks on the left? Who's preferring the one on the left?
Right.
On the left, we've got a picture of some royal regalia with two swords, and that question mark, Prerogative Foundations, should not be there, and it's called Royal Law Prerogative Foundations. On the right, you've got a very, very different set of regalia in a much darker hue, and the words Royal Law is at the bottom, but with a purple background. So those are the two options. On the left, hands up on the left. Or you guys in the room, just choose which one you prefer. Your left. Who's on the left and who's on the right? Oh, interesting. So it's about a 60-40, which has been pretty consistent for most of it. I've got a couple more. Oh, that's wrong. Hang on.
I should also say we are having online. We're having online voting.
Online voting. Ah, superb. On the right with the purple. Well, I can't make this go to the next page. It's not working. Can you? Could you possibly just press next page, Colin?
Yeah, hang on a second.
That's it. The next page is similar to the to the left-hand side one, but with those two things at the bottom added on. So they've got the purple, because I've had that feedback before about having the purple at the bottom, that they like it. But anyway, these are the options. I'm not going to take any more time. Yes. Well, I'm not going to take any more time on the book covers. It's just a little. It's nice to get a feel, but it's been about 60, 50, leaning more towards the other one, but I like the swords. Someone at Cambridge said that matches your personality, Robert. So I might go more with the sword one. Right, okay, next slide, please. That's right. The book will be called Royal Law Prerogative Foundations. It's fair to say that the claims I'm making in this chapter and in this book seriously conflict with the dominant view in public law generally, which I would characterize as a common law narrative or mentality with roots all the way back to Cook and Blackstone. The reason I oppose it is because, in my view, it leads inexorably, as George Letts hinted at a recent chat here at UCL, to the courts challenging Parliament, as Christopher Forsyth famously warned of fig leaves and fairy tales in the Cambridge Law Journal nearly 30 years ago. Project's still a work in progress. Please, if you don't want to feedback today, drop me an email. It's robert.craig@bristol.ac.uk. So I'm interested in any feedback anyone might have. Okay, where are we? Structure again, good. So the next slide, please. Thank you very much. The first line of the book is English law starts with the Crown. This sets the tone for my discussion and has a number of implications that feed through the rest of the book. Related to that first line, the central claim of the book can be summarized in a single sentence. And the rest of the book is an attempt to work through the full implications of that central claim. And that claim is all non-statutory powers of the Crown are prerogative powers. Hence, the Crown has no common law powers. Third source powers are mythical. And the Crown has no non-legal powers, which is something claimed by Adam Perry, in my view, wrongly. I claim that everything done by the Crown is an exercise of royal prerogative without exception. I further claim that the Crown has no common law powers and, for example, does not itself enter contracts. I also claim that powers possessed by ordinary citizens that are analogous to prerogative powers should be sharply distinguished from prerogative powers. I will expand on the introductory basics further below. The other chapter we are considering today focuses on the case law on so-called third source powers, which I hope will please Tom Hickman. who came up to me at an event a long time ago and said, "You must have case law in your PhD book, boss." First I need to paint a bit of background and explain how I get to the issue of third source powers. I'm going to take a bit of a run-up before dealing with the case law, however. The reason for doing this is that the claim that all non-statutory powers of the Crown are prerogative powers has important implications for my understanding of common law, which I need to address. My arguments also lead me to defend an entirely novel definition of the Crown. In short, that definition is that the Crown in the modern era is defined as the legal bearer of the residual prerogative powers. So rather than attempting to define the Crown and then investigating what prerogative powers it has, the methodology should be inverted. Next slide, please. Talking of methodology, I should also mention that I defend what Finnis describes on the incoherence of positivism, which is punchy. I defend that what Finnis describes as, quote, extreme positivism, which he says is unavoidably rooted in Nietzschean philosophy. This expresses extreme skepticism about the possibility of Platonic or objective so-called facts, whether that be about law or indeed morality. And this leads inevitably to a kind of extreme interpretivism based on the coherence theory of truth. And I was having a punch up with Spinning Hugo, those of you know who he is, on Twitter over the weekend on the same issue. In other words, and because I'm in UCL, it's almost essential that I make this concession. It turns out that Ronald Dworkin wasn't wrong about absolutely everything, but has something to say about interpretivism, so I can give him a little bit of love. Okay, so next slide. As the Supreme Court held in Miller 1, that's it. The Crown was once a plenary legal power before the Glorious Revolution. There's Tom! Tom's been in the picture, I forgot about that. Fantastic. I love the joke about Will Pannick bringing his own replacement in case he gets run over by a bus behind him. That was a funny. So the next slide, please. My preferred image for prerogative power, well, there's many images. One of the main images is that of a tree with a single trunk and roots, but with many branches, some of which intertwine. Dicey actually endorses this at one point. But I also think that the prerogative should properly be legally structured analogously with land. So actually, the best way to think about prerogative is to think about land. So the Crown has the freehold, mostly, equivalent to freehold, and the government has the leasehold. From this, I argue that we should distinguish between Crown, capital K king, and lowercase k king. So those are but that's all rooted in Kantorowicz, so I'm not going to go into that now. The diffuse yet intertwined nature of the royal prerogative can be usefully illustrated by considering the relationship between the ostensibly distinct prerogatives of administration and justice. In one sense, the prerogative power to administer the kingdom is the fundamental prerogative from which all others are derived. After all, the power to administer his realm is central to the meaning of being the so-called lord of the manor. The prerogative of justice and the advent of the king's judges is just one of the many prerogatives held by the Crown. All of these are legal powers. I think the administration prerogative has long been overlooked in the literature, but is crucial to my arguments about third source powers. In short, I claim that the administration prerogative delineates the set of powers commonly thought of as third source. It encompasses the normal internal workings of government with limited real-world policy implication. New slide. Blackstone provides a useful definition of the administration prerogative, which I'll let you read rather than read it out. The administration of the country over time came to be delegated to representatives of the monarch who travelled around the country to do so, eventually becoming the circuit judges that we know today. Dicey expresses some wonderment at the speed with which the prerogative of justice under the king's judges was promulgated throughout the kingdom, replacing the variety of local courts, wapentakes and hundreds and such like, with a law common to the whole realm, hence judicial common law. Next slide, please. As Holdsworth pointed out, if we return to the beginning of the 13th century and take our stand in 1215, we can see that the Great Charter has made it clear that the future of English law is with royal justice, and that therefore there will be a law common to the whole of England. This quotation leads to one of my central claims, and possibly my favourite line in the book so far: common law is royal law. Hence the title of the book. Although for reasons I don't have time to explain today, it would be more accurate to say that common law was royal law. This is because I argue that the jurisdiction of the courts was placed onto a statutory footing, which is my answer to Jeff this morning, on a statutory footing by the Judicature Act 1873. The prerogative of justice then went into abeyance. Also notable is that other intertwined prerogatives further illustrate the origins of common law as royal law. This includes the immunity of the Crown from common law, which technically persists to this day, as M and the Home Office amply demonstrate. The prerogative of keeping the King's peace, discussed by Blackstone, is the fundamental basis for the whole of criminal law since Henry II, hence the Crown Prosecution Service, not forgetting the Royal Courts of Justice. I therefore claim that prerogative is not part of the common law. In fact, the reverse is the case. Next slide. Four definitions of common law. In order to show why the reverse is the case, I need to separate out four definitions of common law. There are essentially four different meanings of the phrase common law, and they should be disaggregated far more carefully than they are currently in legal discourse, in my view. The first meaning we can dismiss fairly quickly, which is the use of the phrase common law to describe common law systems as opposed to civil law systems. The second meaning is the one that I think is the most accurate meaning, and the one that I tend to use most of the time when I use the phrase common law. This definition of common law refers solely to decisions of the King's Bench Division of the High Court, as amended by appeal to the Court of Appeal or Supreme Court. The third meaning of common law is much broader. Common law is sometimes used to mean all decisions of all courts collectively, including Chancery, Admiralty, as a set of legal norms or precedents which are taken to be the ratio decidendi of such decisions. This definition of common law is probably the one most people use most of the time. The fourth definition of common law is easy to define, but in my view, deeply problematic at a number of levels. This definition states that common law is defined as all non-statutory law. On this definition, there are in fact only two sources of legal validity, common law and statute. But in the sense of a separate a priori, third source of plenary judicial power and legal validity, authority or legitimacy, common law in this fourth sense does not exist. Historically, common law was royal law was prerogative law. New slide. Some judges still think that prerogative is the basis of common law. The well-known, this is the case in 2017, the well-known and long-established principle that the exercise of the prerogative and the inherent jurisdiction is an exercise of the prerogative. This was a child case where the statute ran out of coverage, albeit the prerogative vested in the judges rather than in ministers. And I just pass over the fact that judges started as administrators, so that's why evidence is so interesting, but let's not go there. It is a serious mistake. Next slide, please. It is a serious mistake to equate the powers of the Crown and the powers of ordinary people. We should also disaggregate public and private law. The necessity for this is much easier to understand if the issue is framed through remedies. I'm hesitating about the public-private one because Lionel Smith, who I knew at Oxford when I did the BCL, just gave a thing when he's saying that private law gets closer to public law, but that was in his Downing speech the other day. This problem is a legacy of Dicey's mistaken boast that it is a strength of English law that everyone comes to the same court and is treated in the same way. Dicey was wrong. The French were right. Royal law dispensed by the King's judges focused on remedies. That is why it is commonly said that English law focuses not on rights, but on wrongs. If a wrong was done historically, then a remedy was sought from the King's courts. The prerogative of justice was There are therefore only two sources, or there were only two sources, of legal validity ultimately in English law: statute and royal prerogative. So in that sense, I agree entirely with Adam Tompkins' characterization of the legal roots of English constitutional law as being bipolar, Parliament and Crown. If I was being mischievous, I would also add that we've seen that same bipolarity in our history elsewhere. So that's the background. Let's do some third source powers. New slide, please. The idea of third source powers relates to the claim that the Crown possesses not just prerogative powers and common law powers, but another type of powers or freedoms. I aim to challenge the claim, defended by numerous leading scholars and referenced in some case law, sort of, that this alleged third source of Crown powers, or perhaps freedoms, exists at all. This doctrine is sometimes known as the Ram doctrine and has received scathing criticism elsewhere. Bruce Harris is the leading proponent of the third source powers doctrine. He vacillates between two positions: whether third source norms are a set of legal powers, or whether they constitute a residual freedom for the government to do anything that is not prohibited. So my central claim is that all prerogative, just to recap, are all Crown powers are prerogative powers and vice versa. New slide. Bruce Harris, relying implicitly on Wade's reading of Blackstone, has suggested, and again, because there's some words which I should just bring up. Yeah. Relying implicitly on Wade's reading of Blackstone, has suggested that A, true prerogatives must be exclusive to the Crown, and B, they must override common law rights. In this, he goes further than Wade, who only argued that prerogative must affect common law. Harris argues that his narrow definition of royal prerogative necessarily leads to the conclusion that there is another source of executive authority, which he describes as third source freedoms. This catchy label has gained considerable traction. New slide, please. Harris centers his arguments on the famous case of Malone. Phone tapping, by the way, that's the meme. Okay, so probably just for royal protesters as well. Right. Harris centers his argument on the famous case of Malone, which is technically the original third source powers case. In that case, the government successfully claimed in the domestic court that it was free to tap phones because doing so was not prohibited by law. This case appears to provide material support for the constitutionally controversial claim that the government has the power to do what an ordinary person can do. The better view, following Fewings, is that the government must provide evidence of positive legal authority for its actions as a basic function of the rule of law, as expressed by Raz. I suggest that equating the legal position of private citizens and the government is a serious error that infuses this entire area of law. It is worth repeating that the narrower the definition of the prerogative, the broader the necessary alternative space that is generated where the government acts outside both prerogative in a narrow sense and outside a statutory power. What is genuinely puzzling, however, is the idea that the government could have a general freedom to do anything not prohibited, as if the Crown could ever realistically be described as or treated as a natural person. Next slide, please. There is a serious problem with equating Crown powers with powers of ordinary individuals. Paul Craig, in his forthcoming book, which he kindly sent me the relevant chapter, describes it thus. I think it's on the next page. Whether the Crown should have a third source power in this latter sense will be considered more fully below. Suffice to say, the answer is not to be found in some misplaced and facile analogy between Crown and ordinary person. This might be the first time Paul Craig and I have agreed on something. The Crown and private persons do not have the same legal powers. For the Crown to have the same powers as ordinary people, the remedies and causes of action that relate to each would need to be the same. This can be easily debunked. The starting point is to recall the argument that English law is best understood through the prism of remedies, which is actually how common law developed and is therefore, it is suggested, the appropriate mechanism for considering these matters. If an ordinary wealthy person decided to set up a charity or a trust or a committee to give away money, this is Wade's example, could that decision be judicially reviewed and quashed, or an injunction or other public law remedy be granted? Obviously not. If the Crown constructs a compensation scheme under ex gratia payments, could that money be subjected to a claim for money had and received if the intention to donate could in some way be vitiated? Obviously not. A chasm therefore separates these two legal scenarios, conflating the two as a serious mistake, and it's Dicey's fault. Even Homer nods sometimes. New slide. One of the most peculiar elements of Harris's definition is that a true prerogative must override the common law. This is even more extreme than Wade, he says it should affect common law. This was flatly contradicted by the Supreme Court in Miller 1. That case held that the prerogative cannot infringe or change, never mind override, quote, any part of the common law or statute law, end quote. Hence, were we to take Harris's definition seriously, the bizarre result would be that there are no genuine prerogative powers at all, since it is established law that prerogatives cannot override common law rights. The category of true prerogatives would be a null set. It is no small irony that Harris therefore appears to think that all non-statutory executive legal powers can be lumped together in one category, whatever he chooses to label it. Strange as it may seem, it would seem that Harris ultimately agrees with me that there are in fact only two sources of executive legal authority, since there are no genuine prerogatives in the narrow sense if this test is conscientiously applied. But there's already a label for all non-statutory powers of the Crown. That label is royal prerogative. Harris's argument in the end comes full circle, and he ends up effectively indistinguishable from Dicey, except for the label. New slide, please. There is indeed an underlying legal power that underpins virtually all the apparently disparate minor powers, including making policies, writing memos, and other stuff that Perry describes as non-legal powers. I mean, it's a prerogative power that's not widely known. In fact, there was only indirect evidence buried in Chitty and prerogatives without anyone appearing to have noticed it. It's the prerogative of administration that I mentioned earlier. When considered dispassionately, I think there's a new slide here and I've forgotten what it's supposed to be. Yes. When considered dispassionately, it cannot be thought controversial that there is a generic legal prerogative power possessed by the Crown to administer the realm independently of statute. After all, the Crown's been administering the realm for centuries. In the treatise on the law of the prerogatives of the Crown, Chitty speaks of the regal executive authority as, quote, supreme executive magistrate, and that the, quote, King of England is therefore not only the chief, but the sole magistrate of the nation. All others acting by commission from and in due subordination to him. Chitty goes on to say that, with respect to public offices merely of a ministerial nature, the Crown has an undoubted prerogative right to appoint officers to fill them, and it is highly important that the various duties attached to them should be properly performed. It is important to make clear this is not direct evidence of the existence of the administration prerogative, rather it presupposes the existence of the prerogative, precisely because it presupposes the Crown's power to appoint officers to administer the realm. New slide. In GCHQ, Lord Diplock also held in passing that those by whom the administration of the realm is carried on do so as personal servants of the monarch who can dismiss them at will. This is a succinct confirmation that the administration of the realm is done on behalf of the Crown, and that therefore it must be underpinned by royal prerogative. There is also Lord Sumption in New London College. Chitty does not provide a neat list of what powers fall under the prerogative of administration, or indeed a tight definition. It is suggested, however, that implicit in the legal prerogative power of administration is the power to ensure that the various duties of government are, quote, properly performed. Hence, the full range of basic administrative tasks encompassed in modern civil service bureaucracy may be safely included, such as writing memos, setting policy, reorganizing departments, and the like. We can explore this further by examining the relevant case law. I don't want to spend too long on the case law, as I imagine most of the Q&A will be on bigger themes, but also I have limited time, so I'm going to get through it. The starting point for my attempted reframing of the case law is that I reject the idea that the executive has a general ability to act as it pleases. Instead, the administration prerogative, like all prerogatives, is grounded on historical precedents, the branches of the tree. What does ordinary or ancillary administration within government normally require? The first example of what is historically being considered a third source powers is ex parte C. In that case, the Department of Health maintained an index of those who are thought unsuitable to work with children. This included both convictions, but also where an individual was moved or resigned, where, quote, the welfare of children, end quote, was put at risk. The list was not published, but employers in the field of childcare were expected to check it. The applicant was on the list. Lady Justice Hale gave the unanimous judgment of the Court of Appeal. The department could maintain the list. She expressly cited Wade in determining that there was no relevant prerogative power, and her reasoning was uncannily similar to Harris, that therefore suffers from the same problems. New slide, please. She said, subject to complying with those rights, it seems to me that private citizens are free to maintain services such as this. I conclude, therefore, that maintaining the list is not in itself unlawful. The problem is that a chasm separates the exercise of public power from the actions of private citizens, as Hale was forced to acknowledge almost immediately in the next few paragraphs of her judgment. If the question is reframed as requiring a consideration of the limits of the administration prerogative, the entire argument is transformed. The Fewings principle would apply. The fact that the scheme was subsequently placed on a statutory footing in 1999 rather suggests that this complex registration scheme went far beyond ordinary administration. It's important to note that ex parte C concerns the quite distinct legal scenario of judicial review of prerogative simpliciter, like Miller 2, as opposed to judicial review of prerogative where it intersects with statute, which is a completely separate area of law, which I have to tell my students all the time, to which we now turn. The New London College case concerned an immigration sponsorship scheme. The way you tell the difference is to think about treaty powers, because Rees-Mogg was held to be non-justiciable because there's no statute involved. And the Miller 1 case, there was a statute involved, so it was justiciable. That's how you tell the difference between the two areas. The New London College case concerned an immigration sponsorship scheme run by the Home Office in which the applicants participated. Lord Sumption held that the sponsor licensing scheme fell outside the statutory immigration regime because it did not relate directly to the position of the student, but instead was, quote, wholly concerned with the position of the sponsor. The question of the scheme's legal basis was therefore an issue. Sumption doubted the third source approach and also the idea that the Crown had all the powers of a natural person, precisely because applying that idea to governmental action might not be, quote, apt. Contrary to the reasoning in New College, I should just say Sumption held there was an implied statutory powers, so he didn't deal with it definitively. Contrary to the reasoning in New College of implied statutory powers, if the action taken to support the statutory scheme were treated as being done under the administration prerogative, that would match Sumption's instinctive legal sense that the government has various administrative powers not always captured in statute. Those powers are prerogative powers. Those powers cannot be used in a way that frustrates the intention of Parliament, relying on the line of case law from Laker Airways through Firebrigade Union all the way to Miller number 1, and on which I've written separately in Public Law Journal, 2019 special edition. So new slide. In this case, this is the Hooper case, complex facts in this case, but I'll try and keep it simple. In this case, a widower claimed to have been unfairly treated because he could not claim the benefit a woman in his position would have been able to claim. He claimed the Secretary of State had an obligation to make ex gratia payments to him to make good the difference, which was based in statute. Counsel claimed money payments are not a prerogative power because paying money was a commonplace legal action and requiring payment would have knock-on effects on other ex gratia payment schemes. This again conflates private persons' power to give away money from the disbursement of public funds subject to public law limits. These legal scenarios are wholly different. Next slide, please. This case concerned, it is Shrewsbury. This case concerned a decision by the government to reorganise local government administration. This might appear at first sight to be a quintessential example of the exercise of the administration prerogative, but for the fact that Parliament had stepped in to regulate the area in 1992 through the Local Government Act of that year. This required changes under any exercise of statutory power to be reviewed by the Electoral Commission, which had not happened here. This called into question the legality of the changes that were made. Lord Justice Carnwath makes clear that, quote, whatever the scope of the Secretary of State's common law powers, they may be expressly or implicitly excluded by a statutory scheme covering the same subject matter. This is a fairly orthodox example of the abeyance principle. Where prerogative and statute overlap, the prerogative goes into abeyance and cannot be used. Only the statutory powers are available to ministers. In this case, that meant the minister had no legal power to reorganise local government without following the strictures of the statutory regime. New slide. I'm not going to go into the question now as to whether Malone can be reframed, which I think it can, as revealing or confirming the idea that the prerogative of preventing crime is part of keeping the peace, king's peace. That's another half a chapter. So in conclusion, prerogative powers of the Crown are the only powers possessed by the Crown. The logical corollary of this claim is the Crown has no common law or third source powers. This chapter has sought to reframe, and the first chapter, reframe and reconsider the so-called third source powers case law, radical or otherwise, Colin, I'm not sure. But I've argued that all such cases should be understood as prerogative cases, and in particular, some can be framed as exercising the prerogative of administration. Thank you very much.
Great, thank you very much. Thank you very much, Robert, for a great presentation. And without further ado, I'm going to hand over to Daniella Locke from formerly UCL, now Oxford, to respond. Daniella, over to you.
Thank you, Colin, and Robert. You can hear me okay? Okay, fantastic. So thank you so much for inviting me to be able to comment on a book which is covering such an interesting and important topic. And I'm sorry not to be there in person, but it's great to be able to connect with everyone online. So in terms of my comments, my focus is on chapter 1. And in particular, the methodology section, as this is the area which is kind of signposted in the document to be in the early development phase. So I assume feedback would be most useful there. The methodology section obviously sets out the foundations on which the book's argument is based, obviously, essentially kind of articulating the standards by which different views on what the Royal Prerogative Act will be based. So there's a very important section, and I think that there's lots to unpack in Robert's methodology, and I agree that it's quite an unusual one, and I'm all in favour of kind of being quite experimental and bringing together new approaches in analysing, the nature of UK constitutional law. Before I start by setting out what I see to be kind of 3 potential problems in the methodology, I did just want to acknowledge what me and Robert probably agree on. And, there's probably not a huge amount that we agree on kind of further down the line in terms of what we see to be important aspects of constitutional law. But I think what we do really agree on the basis of chapter 1 is that there is a tendency of explicitly positivist accounts of what UK constitutional law is to get kind of tangled up in background normative stances in a way that's not very explicit and has a potential to conflict with the kind of status of the account as a strictly positivist account. And that seems to come through in Robert's analysis, that he has a problem with that. And I'd like to say that I kind of agree, and I see that that is a problem as well. Now moving on to what we potentially disagree on, I'll set out what I see to be 3 potential problems in the methodology as set out by Robert. They all relate to what I see to be an ambiguity in the kind of background normative stance I think Robert is taking in his analysis. In particular, I think there are 3 concepts that are employed in a way by Robert, which I worry serve as a kind of backdoor for precisely the kind of moral evaluating that Robert's methodology is supposed to be set against. And so I'll go through these concepts in turn. So the first one is Chesterton's fence, which I had never heard of before, and before I had read Robert's chapter. And so before I tell you what the fence is, if you've not read the chapter, I just want to set out some of the kind of key presumptions that Robert takes in his analysis. So on page 8 of the introduction, he says, look, it's important to be clear that this book is not a normative defense of the current structure of the Constitution. On page 10, the analysis says, this book therefore does not defend the royal prerogative per se, rather it seeks solely to provide an accurate analysis of the prerogative and its function in the modern Constitution when considered in its overall historical and constitutional context. So we see that there's a kind of attempt here to separate out Robert's analysis from some kind of normative defense of prerogative power. At the same time, he describes a prerogative as being a legacy feature, and says that legacy features are not to be deprecated on the basis of not being a rational design feature. He says on page 9, on the contrary, in fact. Which I found slightly confusing, but it made more sense when later on in the analysis, Robert brings in the concept of Chesterton's fence on page 22. And this is essentially, it seems to me, to be a kind of presumption in favor of the past. He describes Chesterton's fence as being a claim that when coming across a fence in the countryside, it is important to identify a good reason for its presence before deciding to remove it or even leave it open. One is only justified in getting rid of it if the reasons to remove it outweigh whatever the original and identifiable good for it being there. So what we see here is a kind of presumption in favor of I don't know, recognizing the importance of the past and, you know, the legacy features that we have in our Constitution. And there's not much in the analysis that goes into justifying why this might be a good presumption to have. And I think that I worry that without having the justification, there's going to be kind of more normative confusion kind of down the line. I mean, so, you know, what is the justification for this presumption in favor of kind of preserving our legacy features of the Constitution? It could be, in the first instance, there could be an intrinsic value to the past, i.e. just by virtue of it existing in the past, there's some kind of intrinsic value of this feature, or there could be an instrumental value associated with the past. So you might think that legacy constitutional features might have particular value in the modern context, insofar as they have resulted in the development of a doctrine about protecting against the arbitrary use of executive power, for example, or they could play a role in developing democratic norms in the UK Constitution, or they could be an expression of kind of great democratic consensus from the past. And so these values are, you can see this is an instrumental value of a legacy feature. You know, why does this make a difference? Well, I think that, you know, if there's an intrinsic value to the past and these past features, that needs to be set out and it needs to be justified. Where does this intrinsic value come from? How can we see it? If there's an instrumental value that we associate with these past features, then I think that there's a concern that this then becomes a kind of backdoor for exactly the kind of objective moral evaluation that Robert is kind of set against. You know, if background legacy features are important because they tell us they develop some important democratic norm, then it might be that then the role, what you think democracy is and the way you think it should be protected, is inevitably going to play a role in how you perceive that legacy feature. Also, on the question of the kind of past and tradition, I do think that there is a risk in terms of the way the analysis is set out, that there's something kind of question begging about the way that Robert sets out his views. So on page 30, he says that while it makes no claim to any objective superiority over any other system, its value in this country, I think this is talking about the Constitution, its value in this country comes precisely from its roots in history, tradition, and familiarity. A modern but historically rooted approach respects the cultures, the centuries of slow development, and those familiar legal values, traditions, and customs which are followed precisely because legacy rules tend to be consistent, blah, blah, blah. And anyway, he says that this means that we need to take seriously genealogy and historical sources. That seems to me to be kind of question begging. I realize that I don't actually have that much time, so I'm going to try and hurry up. So the second concept, which I worry could be a kind of backdoor for the moral evaluating that Robert is set against, is the role of pragmatism. So Robert states on page 29 that his methodology involves pragmatically considering what current practices and norms are or would be consistent with history, custom, and convention. But that does not require any justification in any objective sense, still less than one is reading in any sense objectively better than the other. Well, I worry here that the word pragmatic is doing much of the heavy lifting here and could end up being a kind of, you know, what is a kind of pragmatic analysis? Does that involve taking into account certain values or not? And if so, what values are they, and how is that different from doing a moral evaluation of the Constitution? Third, so this is the role of persuasion in Robert's methodology. So there's those who have read the introduction will notice that there's some discussion of Koch and Koch's approach to analyzing the law. On page 26, the analysis says, it is suggested that the power, undoubted impact, and continuing salience of Koch's arguments could illustrate why the modern and contextual focus of the arguments in this monograph rely on pure persuasion rather than alleged historical events, facts, or moral evaluation in any objective sense. So I was a bit confused about what pure persuasion in this context means and how it can really be safely distinguished between a kind of historical analysis. Are we talking about a priori reasoning here, or are we talking about a form of conceptual analysis? And how can we square the fact that the arguments that Robert is presenting is said to be kind of coming from this angle of taking pure persuasion as the role, and yet at the same time, as soon as you get into as soon as we look at the chapter outlines later on in the introduction, it's clear that there's a huge amount of analysis of history, historical analysis, and you know, like I said, that I worry that in the background we have a lot of kind of moral principles playing a role in the evaluation as well. So yeah, I'll leave it there because I'm running out of time. But I guess just to sum up, I think that the methodology could do with more elaboration. And I think that there's a kind of hazy distinction between moral evaluation and this kind of pure persuasiveness I think it's exclusive positivist approach, and I would really appreciate hearing much more about kind of how we can reconcile the tensions that I've just mentioned. Thank you.
Great. Thank you very much. Thank you very much, Daniella. I am going to now it's going to be my turn to just respond reasonably briefly to Robert's analysis. I'm going to do three things in my hopefully relatively brief presentation. First of all, I'm going to set out what I think is original and interesting and ambitious about Robert's thesis. This will be obvious to some of you, but I want to tease out some of the things that I think make his contribution particularly striking and radical, as I described it. I'm open to correction whether I'm reading too much into your project, of course, but I just want to sort of set out that context. What I think is making this such a different and such an interesting project. Secondly, I want to pick up some of the methodology points I raised by Daniella and add a little bit to that analysis. And thirdly, I want to introduce a comparative element to all of this, which I think will bring out some of the some of the issues here. Let me begin by discussing and outlining what I think is so original about Robert's project. Robert, it's fair to say, leans into the prerogative. Okay, he adopts a broad reading of the scope of prerogative powers, a broader reading than is customarily adopted in UK public law analysis. Now, that's very interesting because there's a deeply rooted tendency in UK public law analysis to read the prerogative narrowly, okay, to interpret it as having a narrow scope, to be protective of common law as an alternative ground of legal norms, to be protective of the role of judges in administering that prerogative common law background, and in general, to treat the prerogative with a high degree of suspicion. Okay, this, of course, goes back to the Civil War. Okay, it goes back to the 17th century. It goes back to the alleged, well, I don't say alleged, it's probably been solved, to the abuse of prerogative powers by Charles I, the overextension, the attempt to overextend existing prerogative powers, and I'll come back to that in a moment, and the way this triggered a response, first of all, through Coke's jurisprudence, the reassertion of sort of the common law as an alternative source of legal normativity, of legal rules, as distinct from the prerogative, but then also it engendered a more general suspicion of the prerogative, which has run like a seam through UK public law scholarship ever since. And there is a strong, deeply rooted tendency to read down the scope of the prerogative powers, to be suspicious of the existence of prerogative powers, to interpret prerogative powers narrowly, and to adopt a narrow historical reading of the scope of prerogative powers, and also in the development of case law and contemporary legal standards, to read against the prerogative, so to speak. I'm generalizing to a large extent, but I think it's reasonably true. There is a suspicion of the prerogative in UK public law, dating back to historical concern about the scope of the Crown's powers. Robert pushes back against that effectively. Robert says much of the tradition is wrong. Much of this established tendency to read the scope of the prerogative narrowly, to adopt a narrow, restrictive approach, to be jealously protective of the common law as an alternative source of legal norms, is actually misplaced. It's historically flawed, and it's misplaced as a matter of principle. So his book is so interesting, I think, because he argues for an expanded reading of the prerogative. And I think he argues it very well. And I have to say, as someone who gets stuck sometimes teaching third source powers to first year public law, and who has regularly a room of students very puzzled looking at me as you try and sort of say, well, there's legislation as a source of government power, secondary, government secondary power, derived power from legislation. You have the prerogative. And then you have this other bag of random stuff, which is actually quite important in day-to-day use. And people have various arguments about it. But your first year undergraduate students, don't worry too much about it. Just take it from me that there is a general view that you have the sort of composite source of general authority, citing Malone, citing a few of the judgments that Robert mentioned. Just bear with me, okay? I've never found that terribly satisfactory. I see the results in student essays. They don't find it terribly satisfactory. And I think, Robert's analysis, if you want, applies Occam's razor. It says, we don't need this ragbag group of ideas. We can just say all of this is ultimately prerogative power, and that indeed there is, in addition to all the prerogative powers that we're familiar with, defense of the realm and so on, there's a broad prerogative function and power to administer the realm. Very, very broad, potentially very open-ended. He says it's there, it's always been recognized to be there. Our understanding of UK public law would benefit if we recognized that, okay? So I think that's what's so original and striking and interesting about his project. Let me move on to my second string of remarks about methodology, picking up from that. I do think that Robert is trying to do something interesting, because he's basically saying, my analysis is based on a best understanding of the historical evidence and historical practice, and it also fits how the Constitution works in contemporary conditions. Okay, and he says this is a sort of an example of sort of exclusive positivism analysis and action. He also cites the concept of indirect evaluation that Julie Dixon has developed so well. He's also citing Dworkin. That's an interesting group of sources. Basically, I think, trying to sort of say, my approach has roots in both Dworkinian interpretivism and indirect evaluation and exclusive positivism. For me, I think this flags up the existence of an interesting problem for Robert. And it's a problem that, frankly, I think bedevils much of UK public law scholarship, whose methodology always struggles with the concept of how do you interpret an unwritten constitution? How do you go about deciding what norm should apply in, for example, a case like Miller 2? And I think there are genuine difficulties there when you're not even reading off a text. I mean, we all know the huge difficulties in reading an abstract constitutional text, but there are also huge difficulties in interpreting an unwritten constitution. And to my mind, for example, you inevitably have to introduce normative considerations. I often laugh and make the point to annoy people that, as far as I can see, UK public law is a vast exercise in Dworkinian methodology, with everyone being in denial about that. But that's something we can discuss later on. Now, it seems to me that Robert has run into this problem that bedevils UK public law methodology. I think his approach is really, really interesting. But you are left, I think, with a series of problems. For example, when it comes to the historical account, Robert very much presents that the prerogative has always been structured around the overarching power of the sovereign. It's the Crown gave courts, the Crown administered the realm. It's the power of the sovereign underpins the whole prerogative. The absolute sovereign power of the sovereign expressed to the royal prerogative, which has gradually got hemmed in by the development of the power of Parliament. However, the striking thing about this is that you will obviously have lots of historical accounts that will say that the Crown was never understood to have such exclusive sovereign authority. Now, I'm not a legal historian, and I'm not going to say what's right and what's wrong, but it is clear that there are, shall we say, accounts of how the prerogative power and the power of the sovereign was recognized in the past that actually understands the sovereign not to be the sovereign font of all authority, but as actually playing a role in some sort of quasi-natural law, structured, customary framework of norms. So when Robert cites historical practice of the existence of the prerogative and says that all of this flows from the sovereign crown, so to speak, as distinct from being a common law creation, it seems to me that at the very least, it is strongly arguable that that was not how it was historically understood to exist. I'll give an example. I hate to pick the example in relation to Ireland, but Robert has an interesting quote about Henry I coming to Ireland and setting up common law courts, with the common law as it came to Ireland flowing from the sovereign authority of the Crown, and giving an example about how all of this illustrates how the sovereign Crown was always understood as the sort of source, the font of prerogative, the font of law. Now, that's an interesting example because, of course, actually, when Henry I came to Ireland, he actually was, technically in a legal sense, giving effect to instructions from the Pope of the day, Adrian IV, handily enough, the only English Pope that has ever existed, who actually gave Henry I authority to bring a bit of law and order to Ireland, which is why for 400 years, Ireland was actually not part of the Crown of England. The Crown was Lord of Ireland under the vicarage of the Pope until the break with the papacy under Tudor realms. So in other words, when Henry I was there, in Robert's example, spreading common laws, using the prerogative powers to administer Ireland, even then, the formal legal position was not that the Crown was the source of sovereign power. The Crown was actually, in that context, giving effect to papal authority. Now, I use that as an example about how, historically speaking, royal power in the UK has always been understood, or at least a good arguable historical account of this, that there's always been restrictions on the scope of Crown power. In fact, there's an interesting contrast with France. I'm reading this rather interesting book on the Parliament of Paris, who makes the point, written originally in the 1960s, but updated around 15 years ago, which makes the point that in France, Robert's account actually corresponds with how sovereign power was understood to be exercised in France. Going back to the Middle Ages, the Crown was the sovereign font of all authority, but that in England, such was not the case. The Crown was always understood to be enmeshed within a common law, customary set of norms, with the notion of the king having sovereign power to create all this law actually being a 17th, 18th century innovation and linked to the development of sovereignty in Parliament. So in other words, sorry, I went on a little bit about that, but in other words, all I'm saying is that Robert's historical account is, I think, vulnerable to the basic claim, this isn't how things were understood at the time, okay? Contemporary-wise, his account is radical innovation. It breaks with the established understanding of the prerogative that's been in place for 100, 200 years. So in other words, I think there is a big methodological issue here. If you can't claim this to be historically correct, without making at the very least some interesting historical claims, and it doesn't reflect contemporary consensus, then you are in effect, I think, Robert, making a strongly normative argument. This is, my account is the best fit, the best understanding of how the Constitution has worked in practice and how it works at the moment. And that, it seems to me, that's a very strongly normative claim. And I was struck at the beginning, you had a passing remark about how your analysis will stop the judges over-policing the boundaries of executive power, which is, I think, a classically normative framework. So in other words, in sort of waving as you do towards positivism and saying I am sort of being a good positivist, I think, as well as being a Dworkinian, I think in reality you're much more Dworkinian, you're much more engaged in normative interpretive projects than you want to than you want to admit. And I think, and therefore I think you need to be more perhaps explicit in arguing why your understanding is the best fit, to use the Dworkinian term. Finally, and I'll shut up, I'm talking a little bit too long, partially to cover up the fact that our third commentator isn't going to be joining us. Thirdly, and I'll keep my final comments brief, I think it's interesting because in putting forth this notion of the prerogative of having quite broad scope, of having a background role in administering the realm, your concept of the prerogative is actually very close to the concept of executive power as it's understood in many other constitutional systems. So in France, there is a very clearly developed concept of the executive power, going back to the Middle Ages, very much embodied in the Constitution of the Fifth Republic. There is a separate and distinct sphere of executive power, including a general power to administer the realm, which is very similar in scope to what you're arguing the prerogative should be understood. The Americans have a similar concept, okay? So actually, your concept of the prerogative actually tallies much more with how executive power is understood in many other constitutional systems, actually understood in broader terms than historically has been the case in the UK. But it's interesting, though, that precisely because these other systems recognize executive power as being much broader than the prerogative is understood in UK terms, these other systems have strengthened judicial review, and direct election of the head of the executive in France and the United States, and other constitutional provisions which flow from the recognition of the true width and extent of the executive power. So I suppose my question for you is, if we do recognize prerogative power as being wider, as being a greater scope, as being something more approximating how executive power is understood in other constitutional systems, are there wider constitutional ramifications that should flow from your expanded notion of the prerogative? Just a couple of comments. Apologies for going on a little bit. Okay, I'm now going to shut up and open the floor to any questions and comments. Obviously, Robert's going to have a chance to get back in after everyone has finished beating up on him and being rude about him. But we'll obviously line up the firing squad first. The supporters, and we can take comments in the room, and I will check that those of you online can hear them. I'll repeat so those of you online can get the gist of what's been said in the room. But for those of you want to comment online, we'll start with a couple of online comments before taking one or two people in the room. I have Tom Hickman and Margaret Cohen to start with, and a few others coming in. But we'll start with Tom and then Margaret.
I'll just say before Tom jumps in that I'm 2.5 hours into my Viva PhD with Martin Loughlin. I said to him, I thought PhD is supposed to be hard. He said, if you got things it's hard, you're not listening. Yeah. So yeah, so this is fine. This is nice. So well.
Thanks, Colin. Thanks very much, Robert. Can I just start by saying I think it's a great piece of work, and I really enjoyed reading it, and I think it's impressive and important. So I have a sort of comment and then I have a question. The comment, which is a very short one, and it's not meant to criticism. On the contrary, there's been a lot of talk about how radical your thesis is, and there's no doubt that parts of it are very radical. But the central point that you've been speaking to today, which is whether there is a third source of power, and the fact that there isn't, I don't think that's a radical claim at all. I actually think that the RAM doctrine and this idea of a third source is itself quite a radical, controversial claim that's not really got much authority, has always been questioned by lawyers, practicing and academic. You referred to Lord Sumption. There are plenty of other examples. So I don't think that is a particularly radical claim. I think that's a positive feature of your thesis, because I don't think, if anything, it's the RAM doctrine that's quite radical, and what you're seeking to do is restore a more orthodox position. And I think that's actually helpful for the persuasiveness of your argument. And I think what's really important is that you've engaged in the exercise of questioning that doctrine, third source doctrine, and uncovering the alternative argument. And I think you've done that very persuasively. So that's the comment. Question. I mean, there are all sorts of points here that arise, but the one point that I wanted to particularly ask you about is the analogy with private powers. And there are two sides of this coin. On the one hand, when you're drawing this analogy, or you're referring to this analogy, you pick fairly mundane examples of private powers. So you're constantly talking about shopping lists. Okay. Now, as a piece of advocacy or rhetoric, that has some force, but it's not really an exact analogy for analytical purposes. So, for example, there are many examples of private entities that do things that have major impacts on private individuals. So you may think, for example, credit rating agencies who assess people's credit, and based on what they decide your credit worthiness is, you may or may not be able to get a phone contract or a bank card or so on and so forth. And there's been examples in the past of, for example, in the building sector, there was a sort of blacklist of companies, so certain companies didn't get any work. Now, there's a question mark about any of that, the legality of things like that, but nonetheless, subject to things like that being rendered unlawful, private companies can do things with massive effects on private individuals that seem much more like the sorts of things that the government was doing in some of the cases, like the list case, the C case that you discussed. So, on the one hand, private parties seem to do things that are much more like, what the government gets up to and the effect of government acts. So when you say, oh, there's obviously no analogy between these two, they're completely different. I find that a bit unpersuasive, because I don't think you're picking the right comparators. The other side of the coin is what the government does. And it seems to me that it's very well focusing on some decided cases, but I'm concerned that if you look more broadly at what the government does, that there's a lot of what the government does that's much more like what private entities get up to. And it may be very difficult at this stage in the development of our constitution to try and justify all that by reference to some prerogative power. Now, you focus on power of administration because it's very easy to say, well, the power of administration justifies, setting up government departments, and if you've got a department with responsibility over X, then it can hold a list or something like that. Fine, but I mean, and I haven't thought of any great examples, but I mean, the government occasionally will engage in joint venture projects on the commercial stage. It will provide aid to certain companies, different forms of subvention, and dealing with international organizations, which is not international law because they're not states. And I'm sure there are myriad examples of things that the government does without statutory authority. And I'm concerned that trying to now find some prerogative basis for all of that may be an exercise that's A, realistically impossible, and B, not very desirable. And so bringing those sort of 2 points together, I just wonder whether this, although it may be, a wrong turn in our constitutional law at some point, it's simply impossible now to conceptualize government activities in any way other than by reference to the Ram doctrine. So, the rabbit's out of the hat, as it were, and it's not going to be able to be put back in by reference to prerogative powers, ancient prerogative powers going back hundreds of years. So I find the overall thing very persuasive, but realistically, it seems to me there are some sort of very practical obstacles and questions about the argument.
Great, thank you, Tom. I think
Shall I reply?
I will say no. Hang on, I'll bring in a few people. I think the same thought had occurred to me actually. Margaret. Sorry.
That's right.
Hello, it is wonderful to see you again, and
Good to
it's
see you
really
too.
refreshing. Can you hear me?
I can.
It's
great to see you.
very refreshing not to talk about the problems Israel is actually involved in. Terrible, you don't want to know. Anyway, I fully agree with Robert on 2 points. First of all, let's get rid of this concept of third source powers. And I'm not completely in agreement with Tom. Yes, we have several functions that are operated by private entities, but if they're doing public function, they should be regulated. And this links to my second agreement with Robert's argument, is that we need to retain the distinction between the rationale of public powers and the rationale of private powers. But here is where we kind of part. I don't know if there's any strong utility in sticking to the title prerogative in order to analyze current executive powers. Now, of course, the British, I'm not British, but the British are very well linked with history, but you could say the same about the originalists in the United States. So the United Kingdom is not necessarily the only one. In any case, and this links to Colm's third argument, we really want to also learn from comparative structures. And we see that in each and every system, at least the ones that we know about, the idea that the executive can act in the absence of statute is either recognized or accommodated. Now, I don't know why sort of sticking to the prerogative as the only title will enable further developing the principles of public law today, if you decide to adopt a very loose version of a vision of what the prerogative is, then fine, you can call it prerogative. In the United States, you call it Article 2 powers, and it's just as fuzzy as the prerogative in the UK. So I think that Weber does a very important work getting rid of Harris's theory. I wrote about that. I was totally appalled by the idea since Malone, etc. But the question is whether we should disconnect ourselves, either re-establish a totally new definition of what prerogative powers are, but that is not, I think, what Robert wants to do, because it again connects to the Crown. I think reliance on the Crown today is very unuseful, let's say. There are various dangers involved. If we mythicize that executive power or government power, state power, is linked with the Crown, we don't want to go to the 19th, 18th, 17th century if we're looking at what the government does today. So I don't have a clear solution for this. I just wanted to point these things out. Thank you.
Great, thank you very much, Margaret. And we will take a contribution from the room. Can you just say who you are?
Yes, so I'm Caroline Morris. I'm a reader in public law at Queen Mary. And first of all, I just wanted to say thank you to Robert and also to UCL for hosting this event. I'm really just delighted to see that prerogative being given serious consideration. I think it's tremendously important, and I'm just really pleased that this, I think, is the second event this year that's been held at UCL looking at prerogative powers. So I'm really, really grateful that these four have been made available. If I may, I've got a question and comment. The first, the comment, which I'm not expecting an answer, and I'm not an ecclesiastical lawyer at all, and I'm also a little bit nervous about dipping my toe into the waters of Irish history, but just in relation to Colm's comment about Henry I and the establishment of courts in Ireland. One thing that I had always thought about the prerogative and one of the big sea changes in the prerogative during the Stuart era was that the monarchy had lost the reliance on the divine right of kings, the idea that they were divinely appointed, that they were there to represent God on earth, they were God's secular representatives. So it seems to me that that might be a way of explaining the authority of the Pope over the king during that period, and perhaps doesn't diminish the use of the prerogative to establish courts. And I say that without any background in canon law or Irish history, but just in terms of thinking about the prerogative.
Thank you.
My more substantive question is about Rand powers, and like Colm, I really share your unease with trying to explain it in a coherent way to students. I've never really bought the justifications, so I'm pleased to see this alternative idea being proposed. I'm really grateful for that. I'm just interested to know what your two things really, your thoughts on the Rand memo and perhaps the recent debate about the authority and the use of that by government and courts. And secondly, do you think that the power of general competence given to local government in the Localism Act is really a recognition that Rand powers don't have proper, coherent justification? If they did, there wouldn't be any need to statutarize that power of general competence.
Great question.
Great. Thank you very much. Excellent question there. 3 excellent questions. No discrimination against anyone.
Sorry.
Okay, we'll let Robert come back, given the fact he's had quite a lot of comments directed in his direction. And then if others want to come in, just let me know via chat, raise your hands, or let me know via chat. So we'll have a second round after Robert is done speaking. Robert.
Right. That's a lot of stuff to deal with. Daniella. That was uncomfortable. Because, you know, I've been chatting about public law for a long time, but I've never really exposed my methodological thinking before. So it's like someone's rooting around in my head. So that's fun, but also a little bit uncomfortable. And also Colin on the same point on methodology. Right, the reason why Dworkin is of peripheral relevance is because I agree with the late and much lamented John Gardner that Dworkin is in fact a positivist, just a really bad one, right? But it's just, he is a positive. He in the end collapses, as Raz and Finnis and various people have pointed out over many decades. His position just is shaped. Raz, I think, says he got to a position where few would disagree, by which he means few positivists, right? So I don't take the Dworkin methodology point at all, save to the extent, and this is where I'm going to link to the Cook problem, or the Coke problem, I'm not sure how to pronounce it. It's a written exam. I say that to my students all the time. It's a written exam. The Coke problem is, I have recently, and I'm talking within the last month, having taught jurisprudence for 20 years, I have recently come to the view that if you take Cook's arguments and you try and look at them in the way that Colin was talking about historically, as in historical perspectives, you could just say they are false because he's a propagandist with no real basis for almost anything he said, but what he said has been so useful to a common lawyer since he said it that it has become accepted that he was actually stating what everybody thought at the time, and everyone still thinks since then. Nonsense. Now, that was my original starting point, but that is to make historical claims about what people thought at the time, which is not, I don't think that's, and this is a recent decision, it's useful. I don't think that's the way to do it. So when I say Coke is, which I would now say, Coke has persuaded almost everybody of the rightness of his arguments. That is not because he was expressing anything contemporaneous or has any objective validity or any evidence or anything apart from the fact that nothing succeeds like success. In other words, he's won. But that's where I can then say, right, he has to a large extent won the battlefield. Not from a historical basis, not from a contemporary basis, not from a philosophical basis, not from a normal. He's just won. Everyone agrees with what he said, even though it doesn't. It's really difficult to establish that what he said had anything to do with what the law was at the time. But that's fine, because I'm going to run with that. That's what the recent move I've made is. I'm thinking, okay, I can say all day till I'm blue in the face that Case of Proclamations does not say, and it's doubtful that he ever said what he's supposed to say to the king. I mean, it's ridiculous, but who cares? That's not the point now. These legal myths, which they are, have now taken over. So I'm going to play the same game. I'm going to go, fine. I'm not relying on history and the contemporaneous or objectivity or principle. I'm going to just argue. This is a better way of drawing on this bits of the history that I'm going to choose to draw on, just like Coke, to make my arguments. And it's pure interpretivism. But it's also what Finnis would describe as Nietzschean extreme positivism, because I also deny that there are morals on which I could be accused of making moral claims by Daniella. No, I'm not. And there aren't any. I've never seen any morals. I've looked everywhere under the table, everything. Yeah? So morals are also claims to power, just as much as claims to power, legal claims are claims to power, and they're legacy based. This is pure Nietzschean postmodern, proto-postmodernism, right? It's just argument. We're all arguing about which bits of history we want to draw on to make the case we want to make. Cook did it really well, and he's winning. But the reason I have a problem with Cook and all his ilk, yeah, is because of what Forsyth said. If we let this go too far, there's only one predictable outcome. And the common law is going to stand up to Parliament, and that's a bad day. That's where I'm going to be like, that's a red line for me.
And that's not a normative.
So what do you mean by normative?
Institutional morality.
Yeah, what do you mean by normative or morality? See, these are just claims to objectivity that I do not share with you. Those are just positions you are taking, which you want to protect a particular point of view. Great, protect it, argue for it. I'm going to argue for a different set. But what I object to is being told that I'm making objective or moral or normative claims when these things are predicated on a correspondence theory of truth, that there's some Platonic ideal out there, Finis style, focal meaning. This is why I attack Barbara in the chapter. Focal meaning, because Barbara's just been captured by Finis, as far as I can tell. And there's this idea of focal meaning or a central case or a central bit of objective morality in Plato's sense, that which we are all aspiring to reach. Nonsense. That's where I object. I'm told I'm making a normative claim. I'm trying to aspire to some ideal. No. I'm against all of that because it's nonsense. Yeah. So that's what I was saying to Spinning Hugo on Twitter over the weekend. It's the coherence theory of truth. And coherence theory of truth is predicated on how many people agree with you. Everybody agrees with Cook. Great. So Cook's winning. Does Cook have any objective points that he can point to and say platonically this is a better way of? No. That's where it's not normative. It's just argument. It's extreme positivism. If I win if I persuade you, and I persuade more people, and I lose if Cook does that. Great. Yeah. Where's the normativity? Where's the objectivity? Where's the Platonic idea? Don't exist. Right. So what I've just said in public is the first time I've connected my historically basically boring positivism with proto-Nietzschean interpretivism in this way, out loud. I've done it in private. Gavin will attest to it, but I've never done that in public before, and I'm not sure. And Daniella, pinpoints that this is new thinking, and she pinpoints the tensions in that, because I'm dealing with a world, even in academia, where almost everyone I talk to is a correspondence theory of truthist. Everybody, implicitly, explicitly, is a Finisian in that sense, of they think there's an objective Platonic reality, and that we aspire to it. Very few people genuinely have challenged that. Why? Because you're challenging almost everything. I am rattling the cup on the bars, and people don't like it when you challenge that. But this is all very deep and not very relevant to Turtle's Path. Right, so let's move on to slightly more pragmatic things. Shall we? That's the deeply philosophically, spiritually, emotionally bit parked for now. Colin also points out that third source powers. See, Gavin said to me, those of you who don't know, Gavin Phillipson was my PhD supervisor, so I've known him for quite a while. And he said to me at the beginning of the project, we are doing more Prerogative in a generic sense, by the way, Robert, third source powers, burn them down. Yeah. So effectively, I'm paraphrasing. That is precisely the task I was set to by Gavin, and on this we happen to agree. Again, it's a rare event, cherish it, yeah. But we happen to agree on burning them down, and that's what I'm trying to do, yeah. And so that's fine. I'm appearing to get some agreement. Where I object, where I'm going to challenge Colin's position, and I can understand it. I'm not saying this is wrong, but it looks as though I'm expanding. I can see that. It looks like I'm expanding the definition of prerogative power. I'm really not. In fact, I think I am actually reducing executive power by saying they don't have the freedom to do anything they want. And I think by classifying it as a prerogative, and we know that prerogatives are done by precedence, by history, by can you point to doing that before? I regard that as far narrower than some general USA-based or France-based, the executive must have the ability to do various things, right? And then you work out what they are. And yes, Margaret's right, that's pretty fuzzy. I think prerogative is way less fuzzy, because you've got to go back to Chitty. You've got to go back to the case law. Find me where you've done something like that before. That's why Northumbria is so controversial. And that, by the way, is why Third Direction is so controversial. Because they didn't do that. They merged together some defense thing and some other thing and did it. And I'm like, me and Gavin, we wrote a case note on it, on Third Direction in the Modern Review going, what are we doing? Like, there was no basis for this. Now, I regard that as actually far narrower, Colin. Narrower, potentially. Just because I've categorized a bunch of things like, and we've been classified as third source vagueness into prerogative, does not mean I'm expanding prerogative. On the contrary, the whole history of the prerogative is being narrowed. It's being narrowed over centuries. It's just that we need to identify what they are, how they should be classified within prerogative, I think, which looks like it's expanding, but it's not. It's actually much narrower and tighter, I think, than these. I'm not a comparativist. I have serious philosophical objections to most comparativism, although I get on really well with Margaret. I just don't accept most comparative philosophically, methodologically, has much to say, precisely because I'm very much convinced that how we got here on Burkean, how we got here really matters in terms of understanding properly where we are, right? So I struggle with comparativism generally, which answers your third point. And in terms of Tom Hickman, I've got to explain this to Tom, right? I'm gonna have to do this in more detail on the book. Okay, so Tom, I'm really serious when I talk about remedies. I'm not when I'm talking to Spinning Hero, I'm not joking. Right, so the really important, and your mentality that's coming across really strongly is you've got to look at it from this point of view of what they can do, what powers they have, what they can, how similar the government's actions and powers and rights and obligations are to a private company that has all these powers and everything. And I'm saying that's all wrong. You're starting from the wrong end of the telescope. You need to go back to the remedies. I say again, if Tesco's or if a credit company or if any of these institutions or organizations does something you don't like, can you bring a certiorari against these guys? No. Can you bring a mandamus? Can you do? No. Why? Because English law starts with writs, with remedies. You find the remedy, you work backwards to find the rights. Remedies are the starting point. That is what shows you why it is wrong to equate government powers with private powers, because you can't seek a money had and received against Her Majesty's government, which is a private remedy. It's a private action, a private writ. These are fundamental chasms between public and private law predicated on the remedies, and to start on the other end of the telescope and go, oh, but the government does stuff that looks a bit like. Now, I've got an example of a case, and again, I haven't unpacked it enough because it's so critical, and the facts are really unhelpful. But the case is Hammersmith, Hazel and Hammersmith, right, which you may or may not remember. People may or may not remember this. So I'll tell you. This case was where a bunch of Muppet local councils tried to circumvent statutory restrictions on their debts by engaging in exchange rate swaps with Goldman Sachs and Merrill Lynch, right? They must have been hiding their shark skin under the thing when they walked in the door. These Wurzel Gummages walking in the door. These guys just took them for a ride. Yeah, so they engaged in swap transactions where they lent 25 million quid, but then they borrowed 25 million quid. So net zero, so they weren't borrowing anything, but the interest rates were different. So the council paid one rate, fixed rate, the Goldman Sachs paid some variable rate, blah, 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 and it was all a mess. And then it all ended up in court because the councils obviously lost in their interest rate swap transaction against the investment banks who do this for a living. And, you know, muppetry from the highest order. It all went up to court, and the court said, this entire thing is ultra virus. The whole thing. You can't do this. You can't, as local council, go and play on the money markets, you muppets, right? That voided the contract ab initio, not because the contract was void, but because you need to disaggregate the first stage, which is the local council's power to do it as a public power, which was exercised ultra vires, and that voids the whole thing. My claim is the government can be treated in exactly the same way, Crown can be treated in the same way. If a minister goes and has a contract with his best mate from the pub down the road, no examples thought of in reality, whatever, we will know the example, there is a ultra vires element that pre-exists that contract before you even get to the contract. And that is ultra vires. If I make a contract with the pub guy in the pub down the road, caveat emptor, that's up to me. And the distinction is that the key distinction is that in the one example, it's entirely private, and when the government does it, or when local councils do it, or when the minister does it, there is what I call a hidden public law element. And that element is determined by the fact that, and it's not necessarily ex gratia payments, Tom, it's simply ministerial responsibility. It's ministerial prerogative, appointment of ministers, that is why Hancock can't do that. Yes, because that's ultra vires his capacity under prerogative of being a minister in the first place. And that fundamental difference is you can bring an ultra vires claim against Hancock for acting outside his powers, because it's a bad faith, it's improper purpose, it's whatever, it's judicial review. It's got nothing to do with with private power. So there's a disaggregation of the public element and the private element in those contracts that I suggest to you fundamentally differentiates between credit card companies having massive power, which I take your point, I'm probably using examples to make my case, shock horror, yeah, but that's the distinction I would draw between those two. But I appreciate that I haven't really gone into sort of depth in the book on that. I need to do much more on Hammersmith just to unpack that, I think. Finally, Caroline, thank you very much. Nice to meet you. Have we met? Well, we've met. Nice to meet you. We were in public law from QF. How the bloody hell did that happen? Right, okay, so nice to meet you. Finally, it's great. Fantastic. Okay, so RAM powers. Yes, well, there's a scathing select committee report where people like Sedley have conniptions at the idea of the RAM powers being used. People look at RAM powers carefully. It doesn't say what they say that it said. It's been attacked by all these people. I'm just, in that sense, I'm joining in the party in smashing this thing, right? So I don't think I'm sort of pushing an open door, fair enough, right? So that's not radical at all to answer Colin's original point. But yeah, so I totally agree with you. In terms of local government, the section 1 point, they've treated as a natural person. I have problems with that. I have big problems with that. But it's Parliament. What can I say? Parliament is all power, is supreme. You can do what it wants. Yeah, and so I do, but that's very difficult. And whether or not you want to reverse engineer, I don't. But if people want to reverse engineer that quasi-natural person thing for local government back onto central government, ugh. Elliot wants to do that. What's why Elliot's supposed to be, Captain Liberal, is going on about how government should have natural person powers in case, and I quote, in case the government can't do something one day. It's like, mate, what are you, Locke or something? So I'm going to have a quick go at Mark at some point in the book on and call him a Lockean quasi. I think Tom wants to come back. I'm not surprised. But we've also got Prince has got a point in the room as well. Okay, so that's my answer.
Great. Thank you, Robert. I should explain, by the way, if you're wondering why myself and Robert are looking down, why Robert's getting agitated and looking sideways, it's because we have the screens in front of us in the table. So we are looking at you online down here, just to explain that.
Yes.
Because I'm conscious that may look odd.
May look a bit odd.
Okay, great. We have a couple more comments. We'll have another quick round, give Robert a chance to respond, and then we are out of here because we have a faculty board coming in here and my colleagues will be invading at 1 p.m.
1 p.m.
Now, in terms of contributions, we have a question from Prince. We have Tom wanting to come back in, but I will read you an excellent question which I've been asked to read out online from the mysterious JM. If we do end up accepting there is a prerogative of general administration, or the formula that you used, what implications does this have for judicial review, given the interaction with justiciability over the years? How does your reading of the prerogative impact upon questions of justiciability and how they play?
Great question.
Which I think is an absolutely excellent question.
Good stuff. And I think
so that's something for you to think about.
Yes.
I'll let Tom back in a moment. Prince, just here in the room. Do you still have a question? And one more, right? 2 questions in the room, Tom, and then we'll go back to Robert.
Great.
Prince.
Okay, mine is just a request for clarification.
Sure.
So you said in the talk, Rob, that for you the Crown is the bearer of powers, and that seemed to me ambiguous between 2 things.
Yes.
And it would be interesting to know what you meant there. So one thing it could mean, and sometimes you talk like this in the book in here, is that the Crown is some kind of separate entity that has and may transfer powers and delegate powers, and that seems to fit the descriptive story you're telling, that you had some sovereign and they had all this power and they kind of handed it out.
Right.
But the other thing you could mean though, and sometimes we talk like this, is that the Crown just is, as an entity, constituted by these powers. So and that's a bit like saying how some people talk about the state. So the state or the Crown has certain powers, power to make law, apply the law, what the courts do, enforce the law, and those powers just constitute the state. And that, I think, fits better your normative story. So the idea that it kind of makes sense of the claim that the state can't do stuff unless it has a power. But those seem like two different things to me. And I just wondered which way you go. So, is it that the Crown is this separate entity which has powers which it can transfer or delegate, or is it just that the Crown is, when you talk about the Crown, it's just like how in other countries they talk about the state, it's just those institutions that have these powers?
Great question, thank you.
Okay, thank you very much. We have one other question from the room, and then Tom online.
Thanks, I'm Scott Dixon. I should apologise, I'm a Scots lawyer and a private lawyer, so I'm maybe getting all of this very, very wrong. But it's particularly on what Margaret made, and also jumping on my left. Obviously, English lawyers love English law because then you sort of get obsessed with English law. And we've been talking about English law, but if I go to the Orange Room and try and find your book, am I looking in public law? Am I looking in English law? Am I looking in jurisprudence? Because I think it's important, because if you talk about royal law, then we've got a sort of fusion problem in 1603. And if you're looking for prerogatives, are you ignoring us up north of the border? And that's fine. Absolutely, totally fine by me. And also, if you're talking about sort of other fusion problem, which again you guys would love to be obsessed about in 1873, if you abolished the prerogative of justice, I don't think you did it up north to the extent that's different. Because obviously, are we talking about the executive here? I mean, should your book be renamed Executive Law? Sorry. Because if you elevate it to the level of the sovereign, to the extent the sovereign really does anything, the way that the sovereign bumps up against Scots law is sort of different to what we've been talking about for the last couple of hours. And it may not be important, actually. It actually probably isn't important. But I just wonder structurally what this sort of differentiation issue that we need to think about.
I will come back to that. Yeah, thank you.
Yeah, I think that's an excellent point. It's partially my analogy to Ireland, actually, and actually more generally how the powers of the Crown were understood historically, is, I think, I would just put a big question mark around Robert's account, both within England, but also amplified by how the Crown was understood in Ireland and Scotland, which I think complicates his historical narrative. But that may not bother him if he's not interested in the correspondence theory of truth, and that the history doesn't matter, so to speak. But I think his historical narrative is complicated by what people understood and continue to understand the relationship between the Crown and public law more generally. But enough from me. We'll hand over to Tom, and then Robert will get a couple of minutes to to sum
Finish
up.
off, yeah.
Tom.
Thank you, Colin, for letting me come back in again. So I just wanted to maybe re-put the question, because I maybe didn't put it sufficiently clearly. So I understand the thesis, and I fully understand the point about that your approach would lead to a more restricted approach to what government can do, and that's completely implicit in my question. And I understand the point about remedies. My question is really about, because I'm very sympathetic to your thesis, as I hope I made clear, but I want, one of the things about it that I'm unsatisfied with at the moment is I'm not clear what the implications would be, or how dramatic those implications would be. And in order to tease that out, it's necessary to look at this analogy with what a private person could do and what could be done under their prerogative, which is not an approach that I've proposed, but indeed something that you've done. That's an analogy that, you've looked at that, you've done the shopping lists, which pop up several times. And so, and it seems to me, so what would be the consequence of adopting this theory, and to what extent, therefore, as I said, has the rabbit got out of the hat? Is it simply too late to try and roll back the position and adopt your approach, because it's just not a practical or plausible interpretation of current government constitutional practice, and perhaps constitutional practice for a very long time? So, for example, it seems potentially to be quite hard to justify, potentially, because I haven't done a historical look into what the different prerogatives might be, but how one would justify quite a lot of what government does and has done, in the commercial sphere, outside this idea of administration. And to what extent is it really plausible to ask the courts to sort of engage in some sort of historical exercise of trying to work out if there's some prerogative mentioned in Anson or somewhere else that might cover some what look like fairly exorbitant exercises of government activity, but which a private entity could do, because I think that unless the thesis has addressed that, it will be unlikely to gain traction, for example, in the courts. And I think the courts will be inherently unattracted by the idea that they should be delving back into historical records to work out whether something the government is up to is ultra vires or intra vires.
Okay, that makes much more sense now. I see what you mean now, Tom. I did misunderstand you. I'm sorry about that. That's a great question.
Very good. Okay, over to you, Robert.
Okay, thank you. I'll just deal with Tom now because it's top of my mind. Okay, so I think the answer to your, and Gavin asks me this a lot, is like, what difference does it make pragmatically to say that governments, when they have an administration prerogative or the ministerial prerogative of appointment of ministers, basically, which underpins almost everything that government ministers then do in this area, to what extent does that mean anything's going to be different? What change is it going to make, right? And I've pointed to Ex parte C as an example of one where there is a difference, precisely because I don't think that this is going to make a big difference, nor do I think it requires courts to go digging in the history. Because if you're talking about dainted style government by contract, where you set us, you have standard contracts, and these things are, become very powerful and very normative in a sense, and to the point where they start to look like statutory instruments because they become standard forms. None of that's affected by anything I've said, because all of those, that's all contracts. And I'm not saying governments can't make contracts. Governments can make contracts. The Crown doesn't. The Crown underpins the government. All I'm arguing for is the disaggregation and the removal of the claim that the Crown makes contracts from the discourse. It doesn't make, I don't think it requires judges to start going and digging about whether or not, but I have to think about that, because, you could think of things like, I know you're totally expert on this, all the telecommunication stuff in Minna 1 that you were talking to me about years ago. Yeah, this is all like licensing and when does it shade from being lots of contracts in standard forms into a quasi-legislative? That doesn't require, I'm not asking courts to go off and start looking for whether or not riding a horse to deliver a letter in 1820 is somehow a basis for that. No. That's not, I'm not saying that, but I can see how it could be interpreted that way. No, that's not what I'm saying. I just want to clarify and disaggregate the role of the Crown from the government, and they are conflated wrongly and inappropriately. And which brings me to Prince's point about, I'll have to think about more about that, Tom, because it's an excellent point. Thank you. About which definition of the Crown I'm defending of the two that he distills from what he's read of what I've written. Short answer is the second one, all right? But the longer answer is that it is, of course, a completely reasonable reading of how we got here to point to the sense that the Crown had a bunch of powers and then there was transferred them to a certain extent look like I'm explaining that when I write about it. But I very recently, and this was a conversation with Craig Prescott, who's in the room, which was a brilliant conversation, which has moved me forward on this massively, which is that I think that we don't take seriously enough how fundamentally connected prerogative is with land. And if you take that really seriously, I think we can actually go as far as saying that we can structure our legal conceptual analysis of prerogative analogously with land, so that actually we can say that the government has a leasehold, a different estate in prerogative to the Crown's or the King's estate in the prerogative, which is a freehold or equivalent to a freehold. It's not a direct claim, it's an analogy, right? Because it doesn't go very far, but it goes far enough to answer the problem that Elliot points out recently, which is that how is it that the government can be judicially reviewed on the exercise of a prerogative if it's the advice to the Crown that they're giving that's being reviewed in Miller 2? Hang on, what's that advice? Is that a legal thing? Or is that not a legal thing? Or is it the Queen's exercise of prorogation that was actually judicially reviewed, but it was the advice? Or was it the people inside Parliament? And the answer I'm going to suggest is that the government's aspect that was judicially reviewed is the leasehold aspect, the different estate in the same legal power. So it's not that it's being transferred. To answer your why it's not A. It's not that we're transferring it, is that I am reconceptualizing the concept of the idea of prerogative analogously with land to point out that there are some there's a Crown aspect to almost all the, I'm going to call these Crown prerogatives, treaty, war, all of the standard ones, where the freehold is still possessed by the Crown or still held by the Crown. That's a legal thing. It happens to be non-justiciable to this day. We open eminent home office. But the government's bit of it is not just advice or weirdly political or convention or anything nonsense like that, because how do you judicially review that? It's a leasehold aspect of the prerogative, and that's what's judicially reviewed. That's what was said to be void in Miller 2. So it's actually the second one, because my final point is on this, from Kantorowicz says, there are many interesting things he says, that the Crown has got different meanings different times. In fact, Martin Lockman said this to me at LSE last week, is that there's no coherent definition. I'm saying, well, let's define it. Now, again, this is not historical. This is what I'm saying we should define it as now, because it's going to be helpful, is that the Crown can be defined as the freehold owner of the vast majority of those prerogatives. And then everyone knows where they stand. Because then precisely when Hancock does something ultra vires, it's that leasehold freehold relationship that's at stake, not the contract that the leaseholder then makes with someone to come onto there to do whatever it is. So there's a disaggregation going on. There's far too much conflating, I think, going on as to whether it's the Crown or the King or this. Now, I haven't got time, but the Crown has almost all freeholds, but there are some that they don't have. Prorogation is one of them. The King ex officio capital K holds that one because there's still an intervention. They has to sign it, but it's a formality. The King or Queen has to sign various of them. So I'm going to split them out and call them capital K King's prerogatives. And then there's a third category I'm calling small k King's prerogatives, which is counsel, advise, encourage, and warn the Prime Minister every week, which can't be done on advice by definition because he's doing it with the Prime Minister, right? So that doesn't work. It's the small k King's prerogative, which they still possess completely. Yeah, now that's how I'm categorizing it. Now, this is just taxonomical work. So to go back to Tom's point, I'm not arguing for the courts to go digging in Chitty. Yeah, that's not what I'm saying. I'm saying I can clarify a lot of these, and a lot of this work is clarificatory, positive. Yeah, yeah, it's clarificatory and disaggregating and helping us to understand what Elliot's question, which is a good question. How do you have judicial review of something that's an advice on how to exercise a prerogative? What is the status of that advice? I say it's legal, got to be legal. Otherwise, how can you have a treaty prerogative advice in Rees-Mogg is non-justiciable, and but when Miller comes along, straight away it's justiciable as a legal exercise of a legal power. Well, what is it? Well, I'm suggesting a leasehold. So that is B is the answer to your question. And the issue with the state is tricky. Lachlan in the PhD tried to spend a lot of time trying to get me to accept that the Crown was the state. I don't agree with him, because there are three possibilities. Tompkins said this to me. There are three possibilities that most people say what the Crown is defined as. One, it's the king. Oh, it's not. That doesn't work. Two, it's the government. No, it's not. Reasons I've already given. Three, it's the state. No, it's not. Because the Crown, if they mean it's the state, that includes Scottish Devolved Assembly and then the Welsh Devolved Assembly or the judiciary. They're not part of the Crown. They're just not. So the idea that the Crown is equivalent to the state, Martin's wrong about this, in my view. Right. So I've got a new definition, and the definition came to me during a seminar in Glasgow, like a bolt of lightning, when Tom Mullen said, and by the way, come back to you, Scott Diston's point, because I went to Glasgow and they said some similar things. And they gave me stuff. Read this, take this. Okay, thanks, I'll take them. They actually gave me the book, they didn't say go and buy it. It was great. So it was so helpful. But in terms of the, I've lost my point. It's about Scottish
dimension, different understandings, different perceptions.
Yeah, well,
and you have
there was a segue. There was a segue. It was
you have
really
1 minute, so
I better get on with it. Yeah. Well,
he was about to tell us what his definition of the Crown was. I'd quite like to hear it, actually.
Yeah. So that was it. So it was
1 minute.
I was in Glasgow.
Thanks, Tom. 1 minute.
I was in Glasgow, and I realised that if you take away third source powers, you take away common law powers, you take away a lot of other of this extraneous barnacles that attach themselves to the Crown, what's left is those prerogative powers that the government still exercises purportedly on behalf of the Crown. Let's classify them, because we have a pretty good idea what they are, and you reverse engineer the definition of the Crown as the bearer of those powers. That's a useful definition, not state or government or king. That's a useful definition because then it's the legal bearer of those powers. It's the reverse engineering of a definition from that. And finally, was there, oh yeah, one, that was, so yes, I'm definitely onto the Scottish thing. I'm going to have to deal with it. I'm not sure how far to go down that road. It's tricky because if you read the Scottish stuff, we read Dan Thomas talking about it. It's like reading someone who's not playing by the rules, because you've got all this history about and you go, and there's someone else going, oh, but the Crown can be sued in tort. You're like, it's like heresy. It's beautiful. And one last thing I'll just say that people, you said earlier on, Colin, that we have an unwritten constitution. Of course, we don't. We have an uncodified constitution. It's all written. But I said the same thing to Neil Gorsuch when he came to London recently, put my hand up because he was saying this about unwritten constitution. I said, look, the vast majority of the US constitution is unwritten because it's all done by case law through the administrative state. None of it's on the constitution. There's one line. There's the government, the president, blah, blah, whatever. And they've got this entire system that's predicated on common law. So the idea that they've got some fundamental distinction between their system and our system, I said that to Gorsuch to his face. He was like, So the Americans seem to think that we have this unwritten thing and that they don't, but I'm afraid they're wrong as well. Thanks very much.
Great. Thank you very much, Robert, for a fabulous talk. I promised you it would be fun, and I think it was fun. And thank you very much to those of you online and for those of you in the room. We'll kill it now. The recording will be available if anyone missed it. And thank you to Robert. We'll look forward to reading his book. And I'm sure, as proposed in the chat, we'll have a future symposium here in UCL where we can thrash out all those issues in much greater depth. So thank you very much, Robert. Round of applause. And those of you online can join in. And we will see you all again soon. Thank you very much.